When someone finally decides to reach out for help, they're usually standing at the edge of the scariest moment of their life. They don't know the right words to use. They don't know which office to call first. They don't know that the law already has a name for what has happened to them, and that naming it is often the first step towards safety. I love that hook, that attention getter. This is where StatuteFINDER comes in, and where it becomes even more powerful paired with Document the Abuse's Evidentiary Abuse Affidavit, EAA. Neither tool replaces an advocate, an officer, a nurse, or an attorney. Both work alongside them, clearing the roadblocks to help survivors stuck, confused, or unheard. They're such good writers. This is awesome. All right, let's keep going. How StatuteFINDER and Document the Abuse help survivors build a case. So today we're announcing a partnership with Document the Abuse. It's a wonderful organization that documents the abuse, and as you can infer, that can be a very powerful combination when you pair that with statutes, your rights, the legal codes that correspond to the abuse you may have suffered. So documenting the abuse is really what gives the statutes the power, because now you have the evidence to back up your rights. So let's read an article that Document the Abuse wrote about StatuteFINDER and our collaboration. This is actually my first time reading the article beyond the first paragraph, so you'll get my honest reaction as I'm reading this. So here we go. Let's see, it's got this nice little graphic there for StatuteFINDER, and it starts like this. Statutes will tell a survivor what the law says. The EAA, that once again, that stands for, remember up here, Evidentiary Abuse Affidavit, so that's what it means, EAA, helps them document what actually happened. Put together, that combination, the law plus the evidence, is what turns a fragile case into a strong one. This article is for everyday survivors and advocates with no legal background, and no legal background is necessary to find statutes that are relevant to an individual case. So average, regular people can use this free resource we're sharing with you. So let's keep going. What is a statute? A statute is a written law created by legislature, one that spells out legal rights, requirements, and deadlines survivors need to know. Citation. Let's walk through what this looks like in real life, from the first call for help all the way to the judge's bench. We're gonna walk you through here, all right? So we're gonna hold your hand, let's do this together. A survivor's path. Picture someone who has been afraid to leave an abusive relationship for a long time. We all know someone. It may have been you, it may have been me. They know something is wrong, but they've been telling themselves that what happens at home isn't bad enough to count. I can relate to this. That belief, more than almost anything else, is what keeps survivors trapped. Here's how StatuteFINDER, the EAA, and a strong advocacy team can change the outcome at every stage. Number one, the first call. Sometimes survivors don't recognize their own experience as abuse, at least not in the legal sense. National research backs this up. Oh, I love citations. Roughly 70% of domestic violence is never reported to police at all, often because survivors don't yet have a name for what's happened to them. They know something feels wrong, but they don't know what language for it. When a survivor finally works up the courage to call for help, whether that's a hotline, a friend, or 911, they still aren't sure what to say. This is where statutes become powerful. Listen up. When a survivor can see in plain language that what has happened to them matches the legal definition of stalking, coercive control, or domestic assault in their state, something shifts. They aren't just describing a bad relationship anymore. They're describing a crime with a name and a number attached to it. That clarity gives them the confidence to take the next step and actually leave, which can save lives. Comment below if that can save a life. This is also the moment the EAA becomes useful. When a survivor can name what happened, the EAA gives them a structured way to start recording it right away. Dates, incident, injuries, threats in their own words, before memories fade or break or fear takes over. This is like literally what I was doing when I was getting abused, like record everything. So I didn't know that I was doing the EAA before I heard about the EAA. This is pretty cool. Statutes give the words. The EAA gives the evidentiary record. From that very first call, the two work together, start building a case that holds up. All right, number 2, filing a protective order. Once a survivor decides to seek a protective order, the next hurdle is the paperwork itself. Courthouse forms are not written for people in crisis. They're written for people who already understand the system. StatuteFINDER helps those close that gap in 2 ways. Number 1, it explains where to go. It walks survivors through which courthouses or clerk's office handles their filings, what forms they need, where to get them, and how the process works step by step. So no one is left behind wondering, a government building alone, or overwhelmed. It also advises which forms and processes can be filled out and submitted online in lieu of a personal appearance. So side note for this, StatuteFINDER is not legal advice. It's never going to tell you what to do. It can only point you to resources, different avenues people have taken in similar situations, and then it's up to you to decide what may or may not apply to your case and what you want to do. Number 2, it helps build a bulletproof petition. Instead of writing a vague account of "they scare me," a survivor can list the specific statutes, which are the codes, your rights, that apply to their situation along the evidence they've been collecting. Side note, the statutes are jurisdiction specific, which means particular to your state or city. So that's why it's very important to have StatuteFINDER so you know the specific codes for your region, and it works worldwide and is multilingual. For example, a survivor will write the circumstances of their abuse at StatuteFINDER and immediately receive a statute number for it. The abuser tried to strangle me in front of my children, resulting in a hospital visit in Illinois. The result is a statute number for aggravated domestic battery, strangulation, 720 ILCS 5/12-3.3, as well as child endangerment, 720 ILCS 512C5. See how smart you sound when you can actually cite the abuse? People take you seriously when you start citing the statutes. This is the point where the EAA does its heaviest lifting. A petition for an order of protection that cites the law and backs it up with a documented, organized affidavit is simply harder to dismiss than one built on emotion alone. It gives the judge something concrete to act on from the very first hearing. Wow. Gonna make me cry. This is good. This is good. All right. Number 3, serving the abuser. An order of protection only works if it gets served and enforced. Well, you're up against an uphill battle here. We're gonna teach you how to get over this. So let's say that again. An order of protection only works if it gets served and enforced. This is often where survivors run into a wall of indifference. Been there. Officers are often busy. Domestic cases can feel routine to the people handling them, even though for the survivor, it's the most dangerous moment of their life. Men, you too. I'm a straight man. This happened to me, and I was abused by a woman. But I understand that abuse knows no gender. Anyone can be abusive. So if you're a man watching this can happen to you very well. This is where urgency has to be built into the request. When an advocate or survivor can say clearly and specifically, "This is a direct order signed by a judge. Are you prepared to let it go unenforced?" The tone in the room changes, and I've done that. Statutes gives the request weight. It stops being a personal plea and becomes a legal obligation the officer is asked to honor. Very true. This is exactly what I had to do because the officers wanted to just dismiss my request. So we're teaching you what works. Number 4, when the order is violated and nothing happens. This is one of the most painful gaps survivors face. They finally have a piece of paper that's supposed to protect them, and then it's violated, and no one seems to respond. Survivors need a way to hold that line. A phrase we encourage people to have ready is something like, "You took an oath to uphold the law. Here are the specific rights, statutes that were violated in my case. I'm asking you not to let this go unanswered." You have to memorize that, write it down. You may have to say that over the phone with the officers that are unwilling to protect you. They've taken an oath, and if they violate that oath, their career could be in jeopardy. You have to use that leverage and know how to work the system so you can protect yourself and be your own best zealous advocate. Speaking from experience, we're walking you through this. Continuing. When that statement is backed up by the exact statute that was broken, it's no longer just a complaint. It's a documented violation that has to be logged and addressed by the police department. Research on protective orders shows that reported violation rates vary widely by study, ranging anywhere from 7% to over 80% depending on the population and how violations are tracked, which is exactly why a clear, statute-backed record of each incident matters so much. This is also where an updated EAA entry matters most. Every violation a survivor logs with the date, details, and how it was reported adds another layer to a growing evidence trail. That paper trail matters enormously if your case moves fast forward later. Okay, where we are, 11 minutes. Okay, so we have about 3 more minutes before I turn off the video because Instagram and the other platforms cut it off at 15 minutes. Let's keep going. It's much harder for a violation to be minimized or forgotten when it's already written down in clear, time-stamped record. Number 5, the hospital visit. If a survivor is injured, the hospital becomes another critical point in the case. Medical records aren't just about treatment. They become some of the strongest evidence a survivor will ever have. The U.S. Department of Justice has noted that a well-documented medical record can serve as third-party, factual evidence that corroborates or establishes the abuse occurred, which makes it valuable even outside a formal courtroom. A nurse's notes, photographs of injuries, and a documented timeline can corroborate everything else in the case file. Survivors often don't realize in the moment how important it is to make sure a visit is fully documented, not just treated. Once safe, the hospital visit becomes another entry in the EAA, tying medical evidence directly to the statute it supports. So we got a couple more, 6, 7, we're almost at the end. So number 6, advocates. Every step along this path is easier with an advocate at the survivor's side. We really value human advocates. Thank you for existing and being there for us. Advocates translate confusing systems into plain language, sit with the survivors through terrifying appointments, and help keep the larger picture in view when a survivor is often too overwhelmed to see themselves. So between StatuteFINDER and the EAA, advocates have 2 tools that work together well. One that identifies the law and one that organizes the proof. That combination helps advocates turn frightening, disjointed story into a clear, statute-backed case file much faster than either tool could on its own. Number 7, standing before the judge. By the time the case reaches the judge, the survivor is no longer showing up empty-handed. There's a file that lists the specific statutes that apply, an EAA fully dated, organized evidence that supports each one, and a clear account of what happened at every stage, from the first call to the hospital visit to the violation order. Judges see thousands of cases. The ones that are well organized, grounded in both the law and evidence, simply move differently through the system. We're trying to teach you how to work the system here so you have the leverage and get the justice you deserve. When a survivor can confidently reference the relevant statutes, backed up with a complete affidavit, and ask for protections like exclusive use of a home, which is free, judges take notice. It signals that this isn't a case built on panic, it's a case built on preparation. Here we have a nice graphic from StatuteFINDER. Feel free to pause the video so you can read the text on the screen. Well, let's keep it going. All right, last minute. The road doesn't have to be this confusing. This kind of story isn't unusual. What's unusual is what happens when a survivor has the right information and the right documentation at each step. Instead of having to guess, stumble, and often give up, that's the gap StatuteFINDER and the EAA aim to close together. Statutes without evidence can be dismissed as optional. Evidence without statutes can feel disorganized and hard to act on, but statutes paired with evidence from the very first call is what leads to a better outcome. No survivors should have to become legal expert overnight just to be safe, but when the law is made clear and the evidence is kept organized at every stage, from the very first call to the moment starting in front of the judge, survivors stop feeling powerless in a system that was never built with them in mind. They start feeling like they have a case because they do. Gee, what a wonderful, well-written article. Thank you so much, Document.